Now, our first presentation is on the relationship between European data protection and non-discrimination law. And we will benefit from the combined experience or expertise of Dr. Félicien Vallet and Gaëtan Goldberg. Félicien Vallet holds a PhD in computer science and currently works as AI lead at the Commission nationale de l'informatique et des libertés, the French data protection agency. He is a research and innovation expert in the European Commission's program Horizon 2020. Gaëtan Goldberg is a qualified lawyer who holds 2 legal master's degrees, one French, one American. He used to work at NOYB, short for None of Your Business. That is the nonprofit organization co-founded by Max Schrems, the Facebook nemesis. But Gaëtan currently works for the Défenseur des droits, the French equality body, where he leads the institution's work on artificial intelligence. And I asked Félicien to speak at our conference, and he kindly reached out to Gaëtan and brought him on board so we can benefit from their combined experience. I am very happy to have you both here, and the floor is yours, Félicien and Gaëtan.
Well, first of all, many thanks, Professor Ruth Janel, for the invitation to participate to this very interesting day where we're going to discuss these issues. As you said, indeed, well, to be very brief, you presented me. So I am working at the CNIL, the French Data Protection Authority, as an AI lead. So I coordinate AI-related actions, either internally, where we try to build basically the position of the CNIL regarding this new field, and also externally, where we try to discuss and convince and share our views with professionals, with other institutions, with researchers, etc., etc. And as you said, Professor Janal, when you asked me to intervene regarding this issue, it is a complex issue for the CNIL because data protection and non-discrimination, it's heavily linked and it's not the same thing. And I thought it would be an extremely interesting opportunity for us to actually have the take also of the Defender of Rights, the French equality body, as you said, and in particular of my colleague Gaëtan Goldberg, as also we work very nearby. So it was an opportunity for, I believe, this presentation and also for us together and our institutions to build something at this occasion. So I'm going to present very briefly the outlook of our common presentation. The idea is just very shortly to explain to you the specificities of these 2 bodies, the CNIL and the Defender of Rights, and also their scope and how also there are some specificities, specifically French. Then we'll show you that we register an increasing interplay between our 2 institutions, and that we also feel that there is a will to carry on and also a need regarding the coming regulations. And finally, we'd like to raise some issues, and in particular regarding the legislation and some hurdles that make non-discrimination laws and data protection laws sometimes difficult to combine. So I'm going to start with the CNIL, and then we'll let Gaëtan follow on with the Defender of Rights presentation. So what is the CNIL? The CNIL is the Commission nationale de l'informatique et des libertés. It was created quite a long time ago. Actually, I don't really know if it's the first data protection authority or not, but it must very well be among the first. Anyways, because it was created in 1978 by the Informatics and Freedom Law. the status of the CNIL is it is an independent administrative authority, meaning that it belongs to the executive branch of the French state, but it is also independent from government, and it can oversee it, and it can raise opinion and also, if needed, sanction it regarding data processing that would be deemed unlawful regarding the legislation. Practically, the CNIL is 18 commissioners that come with various backgrounds. Some are French servants in the with high functions from French Conseil d'État, French Cour de Cassation, and some others are from Parliament, while the last ones are people recruited for their very special skills regarding data protection and technology. So we have, for instance, law professors or computer science professors that are also in these within these 18 commissioners. So this is the commission, the CNIL itself, and also to make the CNIL work, you have more than 200 people, the staff of the CNIL, among which I belong, that actually help do the everyday job. The commissioners they meet in two sessions. One is the plenary session where they issue opinions, guidelines on data processing that could be put in place by that are planned by the various ministries, as we will show later on, or professionals. And on the other hand, you have the restricted committee that is oriented towards what is the repressive action and potential sanctions if something went wrong in the data processing that were examined. My last point about the CNIL, and before letting Gaëtan speak about the Defender of Rights, is about the idea that empowered the CNIL more than 40 years ago. I wanted to, if you can read it, show you the Article 1 of the Informatics and Freedom Law, because I find it very interesting, and also it shed a light on how things are perceived, the perception we have on legislation on digital issues in France. Article 1 states that informatics must be at the service of every citizen, must be developed and take place within the framework of international cooperation, and not interfere with human identity, human rights, privacy, individual or public liberties. So it's a scope very, very broad, even though legislation is really oriented towards data protection. But we can see that the idea is to protect freedom in itself, and somehow it kind of reflects within the missions of the CNIL, because CNIL is obviously in charge of the application of the informatics and freedom law, but also of GDPR and some other texts such as e-privacy. And it is interesting to see that it is not necessarily the case all over Europe that all DPAs have the same mandate and do the same thing exactly. And in France, well, the CNIL is rather powerful in this regard, based on history mostly, and regarding this, actually gathered a lot of complaints, for instance, almost 14,000 a year last year. So it's quite a visible institution. And please, Gaëtan, this is yours.
Thank you very much, Félicien. I'm just going to check that everyone can hear me clearly. Can you hear me? Perfect. So yes, the Défenseur des droits, the interesting part here, and the reason why we're introducing you to this institution, is because of the French peculiarities that they have. As the national equality body, the only thing that we do is not non-discrimination, and that's why I wanted to give you maybe a a bigger picture of what is going on at the Défenseur des droits. So it's an independent constitutional authority where we're competent in 5 different areas. The first one being the defense of the rights of public services users as the national ombud. We're competent to deal with the defense of children's rights. We're the national equality body, like I said, so we handle non-discrimination and the promotion of equality. But we also do the ethics in security services, meaning ethics in police work, but also ethics of private security firms. And lastly, we handle the protection and guidance of whistleblowers. So as you can see, as opposed to other member states, the mandate of the Défenseur des droits dealing with fundamental rights is actually quite broad. And non-discrimination in AI is quite a small part of it, but somehow it meets all of those different areas. So it's somewhere where we have to kind of work alongside all the different kind of departments to ensure that when dealing with an AI complaints, we're able to tackle it. So this institution has large powers of inquiry, but also powers of interventions. When the institution investigates, you can't oppose any kind of trade secret or intellectual property. So let's say if you're focusing on an algorithm that is run by a specific company and somebody is trying to access that content in order to make a showing of a specific discrimination that would be going on. Well, if it's the defender of rights that's investigating, that piece of data has to be shared. Then we also instruct individual complaints in each of the field of competence that I described. We resolve conflicts through mediation. So for instance, if you have somebody who'd be laid off because of because of pregnancy, you could have the defender of rights stepping in between the company hiring that person in the first place and her. In that way, we kind of help avoiding going through courts through that mediation process. The defender of rights can also intervene in support of civil and criminal transactions and make observations in ongoing court proceedings. What we also do quite regularly is to make observations before Parliament, where the defender of rights is being heard before either the National Assembly or the Senate, meaning every time we see a bill coming in that would kind of interfere with one of those areas that are described, the defender of rights has the power to say something and to ensure that those observations are taken into account. And last but not least, the defender of rights name is Claire Hédon, and she's named by the French President of the Republic for a term of 6 years. And if we want to step into that presentation now and the reason why those institutions are working together, the first point would be to explain how there's an interplay that's going on. Like Félicien just rightly described, Article 1 of the Loi Informatique et Liberté is quite broad, meaning there are a number of circumstances where both institutions would have standing to actually do something. And so historically, actually, the Defender of Rights is a member of the CNIL by law, meaning every time the CNIL decides on something, the Defender of Rights has the power to step in and say something or maybe complete on a number of points. If you're dealing with fundamental rights, it's sometimes easy to kind of combine those fields of expertise to ensure that when the CNIL says something, we can benefit from the expertise of both institutions. We also have the power to jointly investigate on the complaint. So if tomorrow we were to receive a complaint about, let's say, a facial recognition automated decision-making system, well, that would be the possibility to have the Defender of Rights ruling on non-discrimination issues and have the CNIL rule on data protection law. Something that I should have explained to start with is also that while the CNIL has the power to sanction actors and specifically companies or fine them, the Defender of Rights only has the power to make recommendations. And so in that regard as well, the fact that we get to combine our expertise and our fields of competence makes it quite relevant, I believe. And so in the past, we've had a number of collaborative projects. There's this guide that we drafted that was meant to measure discrimination within companies. We also put together a kit for children to tell them a little bit about, how to be careful about what you're doing with your personal data, but also how to handle non-discrimination when it takes place within the setting of digital services. There was also a CNIL report on how humans can keep the upper hand when dealing with algorithms. So it's a collaboration that we've been having over the years, but the thing is, it's been intensifying in the last couple of years, and we believe that automated decision-making systems are a core reasons for this. The thing is, automated decision-making systems could be the game changer here. Within the Defender of Rights and the work we've been doing on algorithms, we kind of observed over time that we had to knock at the CNIL's door more and more and ask for different pieces of information. Since 2015, where we released the guide on hiring while using digital tools, we kind of realized how both areas were really being intertwined, and we started this collaboration. Then we also released a guide dealing with automatically ADM systems that were dealing with fighting fraud and how these systems can be discriminatory. So there was a slide dealing with the specific issue of biases within algorithms. And then the case that really shed light within the institution on discrimination taking place through algorithm was the Parcoursup case. And maybe you're familiar with it. It's a little bit familiar with the Off-Qual case that took place in the UK. So Parcoursup was basically, and it's still a platform where A-level candidates would register a number of choices of the public universities that they would like to attend. And through that system, they were picking those universities, and we realized that there was the selection could take place through the use of algorithms. And so for the first time, the Defender of Rights made a number of decisions. The first one being that, you had to take specific care of applicants with disabilities because they were handled in the exact same way as other candidates. So you had a true risk of discrimination here, saying because that specific student had a big break within his schoolwork does not mean that that person is as equally qualified. It's just that you need to take into account those specific attributes. And then another decision that we made on this specific system had to do with the transparency of the procedure. Basically, in France, you have the Loi pour une République numérique from 2016, which, when the decision is made through an automated decision system that leads to an administrative decision, you have the right to obtain certain pieces of information. And there was a whole kind of scandal around what types of information can the candidates obtain when it comes to understanding how they're being selected before they can access to those universities. And in the end, we obtained a decision from the Constitutional Court that's a little bit, it kind of weighs the pros and cons, basically, because it tells universities that they have to release the criteria that they're using and relying on to select students. But at the very same time, it does not force them to publish the exact criteria that are used before the selection takes place. And something that the Defender of Rights raised is that some of the universities were relying on a criteria that was using the school from which students were from in order to select them, which in the view of the Defender of Rights was quite risky with regards to indirect discrimination, because you could discriminate with regards to the origin of students and the place of residence. And so that's something that we're still observing, because it was launched in 2018 and the decision from the Constitutional Court took place in 2020. So that's something that we're following through, and we're having talks with the CNIL in order to maybe better understand how the algorithms are working. So that's something where collaboration is still ongoing. Then in 2021, this year, the Defender of Rights released a report on biometrics and the urge to safeguard fundamental rights in that regard. So taking into aspects, the chilling effect that this could have, but also the risks when it comes to non-discrimination. That's also an area where we've been having many talks together with Félicien, actually, in order to make sure that we were on the same page. But I believe the piece of work that we've been doing together that deal with this is a report that we drafted together in 2020. But before I talk about this, I believe Félicien has a few words to say about data just, which is also an area that we're dealing with both discrimination and equity.
Yes, thank you, Gaëtan. Actually, you were just going a bit, just the next step, and well, I'm gonna just spend just a few seconds to show this. But I think it was interesting because we saw the starting when the issues of meeting the competencies of defender of rights and the CNIL meet, and well, starting from the defender of rights, and now on a CNIL perspective, we had an interesting case with the data-just algorithm. Well, and I'd like to raise this for you. Data-just is data processing that was put in place in March 2020 by the Ministry of Justice in France, and the idea is of data-just is to build based on the extraction and the exploitation of data contained in the court decisions, built an algorithm that will help calculate the compensation of personal injury in order to produce guidelines of what you could expect if you were harmed in such or such context. So for the professionals, for the judge who actually have to allocate amounts, and also for the general public regarding what they could actually expect. And for this data processing, the CNIL had to produce an opinion, and it was really interesting. And there are two major takes, at least for me, that I wanted to expose you. The first one is not exactly related to discrimination, but still interesting, and I'll talk about it very quickly, is the fact that for regarding AI, you have to separate what is training and research about when you develop your algorithm with what is the production. And in the very beginning, Ministry of Justice wanted to have in his decree something that would encompass everything. So access to many data to actually try to decipher what would work better. And it was actually a real issue on a data protection standpoint, because they didn't really know what they were actually needing, and they wanted to have all this data. So first remark by the CNIL was, well, you need to have two separate data processing, one for training, where you can actually process more data because you don't really know the design of the algorithm. You'll end up with what data you'll actually need to produce this tool, and then the production phase, where you actually know very well what you have, what you need, and then it can actually go into production and live its life as a product itself. So that's the first take. And the second one is this one, definitely related with our topic, is about biases. And this is and in its deliberation, its opinion, the CNIL stated that given the sensitivity of the information that you can find in court decisions, specific attention had to be paid to the development of the algorithm and the presence of potential biases based on, well, who knows, maybe a geographic location, gender, or ethnical origin, etc., etc. And the CNIL stated that it wanted a report at the end of the experimentation, at the end of the development phase of the algorithm, several months after, to actually show and assess how this discrimination risks were taken into account. And the idea behind it, even if it's not in the deliberation, is actually to also co-investigate this with Defender of Rights and see how we advance on this issue. So an interesting point where CNIL actually takes the issue of non-discrimination, even though it is not exactly its everyday job, but to make the link and make sure that nothing goes unnoticed or in a void. I leave you the floor, Gaëtan.
Yes, and so basically, I believe it's through this sort of work that we intensified our relationship, and we kind of decided to, you know, draft a report together, organize a seminar, talked with experts. Basically, we organized a seminar in June 2020 dealing with algorithms and how we need to prevent automated discrimination. And through that seminar, we shaped a number of recommendations that you'll find in that publication. Basically, we exposed the risk of ADM systems with regards to non-discrimination law. We looked at biased data sets. We took a stance on technology as being non-neutral, and we explained the urge to encourage research in the field, to increase transparency, and to regularly audit these solutions. As you might know, these are things that were told from researchers for quite a long time, but we believe it's important that independent authorities also step in and make a point in this regard. This actually made us realize how important it is to maintain an interdisciplinary approach on these issues. And basically, the main takeaway for us was that, you know, we need to work beyond individual complaints, because the reason is what we observe when dealing with non-discrimination law when it comes to algorithms is that it's quite difficult for victims to identify these discriminations. And while the Defender of Rights or the CNIL both have the power to kind of investigate things on their own, we do not receive many complaints in that regard, at least at the Defender of Rights. And we believe that things will go a lot faster if we were able to pick on a complaint and investigate it down the line. What I'm saying here is that basically there's a lot of discrimination that's ongoing and that's being unnoticed. And so we're trying together to shape an approach where we can better tackle this. So what we've observed through that report, but also while doing our own research, is that there are a number of legal hurdles, meaning areas where non-discrimination law and data protection law don't really match. And this is the next thing we'd like to talk about. So first of all, there's this provision within the Informatics and Freedoms Law, the French Loi Informatique et Liberté, that states specifically in Article 95, that's displayed on the screen now, that says any profiling that discriminates against natural persons on the basis of the special categories of personal data mentioned in Article 6.1 is prohibited. So Article 6.1 here relates to special categories of personal data as adapted from the GDPR's Article 9. But what we observed here is, you know, you have that one provision dealing with non-discrimination within French law, but it only deals with special categories of personal data. And French law has many, many different grounds of discrimination. In fact, we have 25, including physical appearance, lifestyle, age, marital status, but also things like social precarity. So there's a hard kind of line to draw here. Do you let the free flow of personal data take place, or do you kind of restrict all of that flow to kind of make sure that all of these 25 grounds are treated in the same regard within the special categories of personal data, but also meaning that then you get all those restrictions that have to do with explicit consent or et cetera, et cetera. But we believe it's difficult to rely on that only provision when it comes to, you know, profiling that discriminates against natural persons, because it could relate to any kind of those 25 criteria. The reason behind this is probably because France is one of the member states where all of these criteria exist, but it's not the case in other countries. I am not sure, to be clear, but I believe it's important to kind of realize that profiling that discriminates is unlawful, whether it takes place within that special categories of personal data or not. And the Defender of Rights has tending to tackle those discriminations. But so the thing is, it matters as a fundamental difference when discrimination comes into play. You know, within a transnational setting, what if you'd have a discrimination that takes place with a company that's based, let's say, in Germany, and then you'd have someone lodging a complaint with the Defender of Rights in France? Well, would we be able to rely on that specific provision? Theoretically, yes, but procedurally speaking, it makes things a lot more complicated, and that's why we have huge expectations when it comes to the Artificial Intelligence Act, dealing with guidelines and how we can actually better work within transnational settings. But I'll let Félicien say a word about that in a second. The second legal hurdle that we identified has to deal with storage limitation. So proving a discriminatory practice while complying with the GDPR storage limitation principle is actually quite complicated. As you would know, Article 5 of GDPR talks about, it says personal data shall be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed. But that purpose does not mean identifying non-discrimination or discrimination cases. Discrimination claims in France have to comply with a statute of limitation that is of 6 years. And so what's going on in practice? Well, basically, you have a number of actors that will tell the defender of rights, well, I had to delete that data because I have to comply with the storage limitation principle. And then in other settings, they go to the CNIL and say, I have to keep that data because what happens if there's a discrimination complaint? What if I have to comply with it? And so sometimes we'd observe actors having, very different views, whether they talk to us or they talk to the CNIL. And I believe it's also another example where, you have both institutions that need to have that ongoing conversation, because what if an actor is doing a retention practice that has nothing to do with making a showing of discrimination, but only wants to kind of use that personal data to its own benefit, while it's not necessary anymore to the processing operations it was doing. But also how to ensure that data that's needed to bring proof of discrimination is being retained. So that's another legal hurdle that we identified. And the case I was actually mentioning happened in real life, dealing with the French housing market. Basically, the CNIL was drafting guidelines about how to help housing market professionals in France, and to kind of give them an idea of how long they could store the data that they were using when renting properties, for instance. And we observed that they had a very different version of what they were saying to us or what they were saying to the CNIL. And so we believe it's important also in that regard to maybe have a clearer view on, what we should share as, when is that data being deleted, but also, do you really have to keep it for 6 years to make a showing of discrimination? There's a thin line. And that brings us to the next legal hurdle.
Thank you, Gaëtan. Indeed, the last legal, the next legal hurdle we wanted to raise is about the tools that we have regarding accountability and transparency, and in particular within data protection, the DPIAs. When you read GDPR Article 35, you see that the motivation behind DPIAs is actually to provide a documentation that for processing likely to result in a high risk to the rights and freedoms of natural persons. And it's actually very, very large focus, but as of today, at least at the CNIL, from what we see, but I believe this is shared generally within the DPAs. These discrimination issues that go into this very broad focus is not taken into account, whereas the text says that it could actually be. So there is a real question about tools, about method of how we ask on the how we ask professionals, how we ask institutions, organisms to show that they actually took into account discrimination issues and how they prove it. With Gaëtan, we also wanted to tell you about the Loi pour une République numérique that he quickly talked about within the Parcoursup case a bit earlier, because we think it's a French specificity that is of interest, and that could be a source of inspiration. The Loi pour une République numérique states that for data processing that take place between administration and and the general public. In the case of an ADM, there should be, if an individual actually asks for it, the communication of various information, and in particular those that I wrote in this slide: the degree and mode of contribution of the algorithmic processing to the decision making, the data that are processed, the sources, also the parameters of the processing, and could be their weight, whether you want to to have more weight on one type of data or one or another, applied to the situation of the person that actually asks for the communication, and also the operations carried out by the processing. And the feeling we have with Gaëtan is that this proposition that actually applies only for public administrations could be a good starting point to actually be more specific in regard to what we find in Article 13 that is of GDPR, that states that the individual can, in the case of automated decision making, have information about the logic involved, but this is still very kind of fuzzy, very broad terms. And as of today, the feeling is that within algorithms that are put in place in a private sector, we could have a much more important transparency, that it could be largely increased, because as of today, the professionals, they hide themselves, if you can say so, behind IP laws and the vagueness sometimes of the text. So that was something we wanted to raise. And we are arriving at the end of our presentation. We wanted to loop with the AI Act that will be obviously very discussed today. And we were wondering, is this project of regulation, is it not a starting point to try to fix these issues, to go above these hurdles that we pointed? As you know, the AI Act actually is built to take into consideration the risk that these systems that can that they raise to the general public. So there are risks to health, cyber risks from opacity, and also risk, and this is very present in the text, related to erroneous data, biased result, discrimination. In particular, when you go through the text, you find, and well, that was my count, but we could be made more precisely, but 9 times you find the word bias, and 12 times the word discrimination. So this is something that is very, very present in the project of regulation. And also, I think we can find 2 very important takes regarding discrimination in the AI Act. The first one is that, well, AI systems that are subject to biases and that could have very strong implications for the general public, for the individuals, they have to be classified as high-risk systems. So this is kind of a criteria of classification. And also, and very interesting for us in regard to these legal hurdles, the fact that special categories of data in regard of the GDPR could be processed to make sure that biases monitoring is taken into account in these high-risk systems. So by this, creating a legal basis for the processing of special categories of data, something that is actually very new and well, has to articulate with GDPR. However, and this is the last slide we have, and Gaëtan, feel free to jump in to conclude with me. We also have the feeling that the proposal does not go necessarily far enough, and in particular regarding the organization between potential regulators. Well, it is not very clear as of today, obviously, who will be the national competent authority, and will it be the same in every country? Will it be specificities? But we necessarily feel that there will be a great challenge of articulation within the various regulators that are impacted by these AI acts, be it on a data protection standpoint, or consumer protection, or gender equality, or regarding equality bodies. Well, all these organizations will have to articulate, and the risks are multiple regarding this. Governance could be absolutely unworkable. Also, and that is derived, you could have too many obligations for professionals because of all these regulators that are linked, and a lot of things asked for them to do. DPIAs, documentation regarding the AI, production of indicators to make sure that the system do not discriminate, so on and so forth. So a lot of things, and that could be something that is really really a stopping point for professionals. That's to be resolved. And also another risk that we identified is the fact that the AI Act doesn't deal with end users as of today, neither on an individual standpoint as the GDPR does, nor on a collective standpoint. That is something very crucial for the detection of discrimination, because you actually need to see it through a group of individuals to actually raise the fact that discrimination occurs. So this is a major issue, as the fact to raise complaints can actually help identify discrimination sources. And finally, and please jump on, Gaëtan, jump in again if you want to. But we also feel that there is a great need of developing tools to make sure that this proposal for regulation works as wanted. So the first one would be, and we discussed it a bit earlier, is how do documentation and DPIAs coexist? What do each of them must integrate? And also we should think and to bring practical solutions, and for instance, maybe provide guidelines about how should biases be computed, should specific metrics be defined, in what case, for what applications, and all this is very open as of right now, but we feel it is essential to ask and advance in this direction. Gaëtan, please, if you have a last word to say, please feel free.
I think you've covered most of it, Félicien. We could spend the whole day talking about the AI. But my understanding is that indeed we're lacking a lot of guidance when it comes to how it's going to take place in practice. Just for example, when it comes to that future authority, how is that authority going to interplay with either the CNIL or equality bodies? What if it's the CNIL taking that role? Does it mean that we need to reshape our relationship, and how is that going to play in practice? I believe that presentation was more to give you a glimpse at what's going on within our authorities than to discuss the legal peculiarities of data protection and non-discrimination law, but we're open to take any kind of questions that you might have now.